Laws are said to evolve with time, but what really brings about a change in a law? It is the society. Individuals evolve with time, resulting in the society at large changing. A major incident converts the individual anger into public outrage, and this is the final push that results in the changes in law. India has always faced a problem with rape laws and their implementation, much to the ire of the general public. The loopholes, arbitrariness present in the laws governing rape in India are too many to begin with. However, as mentioned before, only after the general public starts feeling discontented with the law at hand can a change begin. Welcome back to Lawwire, where we try to traverse and demystify the unique journey legal development in India has taken over the years. Do watch the video till the end to know the monumental impact of the incident when Rakshak became Bhakshak. Imagine this, the year was 1972. In a remote village in Maharashtra, an orphan girl aged around 14 to 16 years was in a police station with her brother and some acquaintances. While everyone was leaving the police station, a policeman asked Mathura to wait. Subsequently, when all the others were waiting outside, two policemen raped the girl. On getting to know of the incident, the people assembled outside the police station forced the police to file a case against the two policemen by threatening them that otherwise they'll burn down the police station. The case was finally filed. The Sessions Court acquitted the policemen of any grounds of rape. The High Court reversed the judgment of the Sessions Court and held that the policemen were guilty of rape and sentenced them accordingly. The Supreme Court's view was, however, very different. A bench comprising Justice A.D. Kaushal, Justice Jaswant Singh, and Justice P.S. Kailasam held that the girl was habitual to sexual intercourse and had no injury marks on her body post the incident. The court laid down the difference between consensual sex and rape and said that the intercourse that happened between the police officials and the girl was consensual in nature and thus not amounting to rape. Yes, not amounting to rape. The court also noted that the girl might have lured the police officials into having intercourse with her. Stating the above reasons, the court reversed the judgment of the High Court and acquitted the police officials of rape charges. The aftermath. While the society was already upset, thinking about the nature of offence that was committed, the acquittal given by the Supreme Court added to that pain. So much so, four eminent Indian jurists at that time, namely Professor Upendra Bakshi, Professor Vasudha Dhagamvar, Professor Raghunath Kelkar, and Professor Lotika Sarkar, wrote an open letter to the Chief Justice of India regarding the judgment, stating that, I quote, "This is an extraordinary decision sacrificing human rights of women under the law and the Constitution." The letter also went on to say, "You will no doubt forgive us for this impertinence of writing an open letter to you. But the future of judicial protection of human rights at grassroots level in India at the turn of the century, a concern we all share as citizens and as lawmen, leaves us with no other and better alternative." This letter was proof enough of the angst in the public towards the judgment passed by the Supreme Court, and thereby the Parliament realized this angst and brought about major changes in the law post the judgment. Thus came into existence the Criminal Law Amendment Act 1983. Nearly about 11 years after Mathura was raped in a police station by the men sworn to protect her. The main and primary objective of the Act was to legally make provisions for differentiating between consensual sex and rape, and the Act did so by introducing Section 114, Subclause A in the Evidence Act. This section stated that if the victim said that the intercourse was not consensual, then the presumption will be in accordance with it. Also, sections were added in the Indian Penal Code, making custodial rape a graver offence than rape. These amendments were applauded and welcomed by the society at large, and thus this was a major change in the law that came about by the public outrage over the lacuna in law present at that time. If you like the video and want more of the same content, please do make sure to subscribe to our channel Lawwire. Also, feel free to suggest us topics or case laws you would want us to cover. Thank you. Jai Hind.